Good morning, my name's Keegan van der Linde. I'm a senior legal consultant, and I'm joined today by my colleague Neeosha. Neo, would you like to just introduce yourselves?
Thanks, Keek. So, hi, I'm Neeosha. I am the Deceased Estates Administrator.
Lovely, thanks, Neo. So I think today, Neo, we're here because I guess the obvious point, it's Wills Week, you know? So I think to start, I mean, we both know Wills Week it's an initiative that was started by attorneys to help. It helps people, obviously, with preparing wills for them and stuff, but the main cause of Wills Week, I think, was to bring recognition and knowledge to the public, you know, to just let them know the importance of what it means to make a will and what it means to plan your estate in case anything happens to us, you know, you pass away suddenly, etc., and what are the consequences of not doing it as opposed to doing it. And Wills Week is designed to help bring that knowledge to the public and to help them. So I guess we thought it would be just a nice opportunity for us to just sit together, have a conversation, and maybe just talk about it, you know. And I think to start it off, I want to just have a chat with you, you know. Let's go to the basics. Yeah. If you look at South African law, what's the basic when it comes to passing away? What governs death in this country, I guess, ultimately?
All right. So I think it's very important to know that when it comes to death, we are governed by two very important pieces of legislation, one being the Interstate Succession Act and the other being the Wills Act. And when it comes to how your estate is therefore administered, we are then dealing with the administration of deceased estates. However, how your estate is administered is determined by either whether you die with a will or whether you die without a will.
Perfect, man. Thank you very much. Sure, that's a lot, and it's good to know. So let's go then on. I guess my next question would be, let's start at the default. What happens when you pass away? I'm just me now. I don't have a will, and I end up passing away tomorrow. What happens without my will? What's going to happen to me, to my family, to my possessions? How does that work?
Okay, so if you have to pass away without a will, basically your estate is then going to be governed by the Interstate Succession Act. So basically, this is now legislation that has created a framework to accommodate for your closest relatives in your estate. So that being your spouse, your kids, and your parents thereafter. And when it comes to interstate succession, it is quite a rigid framework. It does account for only your closest relatives. So should you pass away not having drafted a will, the line of succession will then kick into effect. I think also what's very important is that when it comes to interstate succession, sometimes we live in a day and age where marriage may not be the only institution of a family being created. So your marital regime, number one, is important, but also if you don't get married, your life partner may be excluded, any stepchildren may be excluded from your close blood ties in terms of the Interstate Succession Act. So I think it's very important when people consider, or when they think about death, to take these things into account when it comes to interstate succession.
Sure. Wow, that's very interesting. Now, let me ask you, if I pass away and I have children, what happens when I pass away to my children inheriting? How does that work? You know, if they're still minors or if they're past age of majority, what does the law and the interstate succession say about that in general?
Okay, so one thing about interstate succession, yes, it will account for your children, but it doesn't give you autonomy to dictate who should be in charge of your kids when you pass away. So the law of interstate succession will obviously leave the natural guardian in charge of your beneficiaries, especially your minor children, but it doesn't allow for there to be any flexibility around the inheritance that you leave your children. So for example, if you were to pass away, yes, your spouse, who may be the mother or father of your kids, will be the natural guardian. However, they won't have control over the inheritance that you leave for your kids. So that money will end up going into the guardian's fund. Also, if you and your spouse had to pass away, then the interstate succession doesn't leave any room for who should be the next guardian to take care of your kids. So those are two very important things when it comes to interstate succession. I find that as an administrator, your kids need to continue, obviously, after you've passed on. And if the inheritance that now they gain through interstate succession is left to the guardian's fund, it kind of creates a little bit of of difficulty when it comes to the natural guardian or the guardian that is now taking care of your kids, because they are going to have to apply to the guardian's fund to have that money available or made available to maintain your child after you have passed on. Sometimes it's also the money can lay there in the guardian's fund until the minor turns 18, but God forbid, if your spouse or the guardian that's in charge of your minor at the time passes away without them informing the minor child that, hey, when you turn 18, there is funds available for you in the guardian's fund, and you need to go and have a look at it or apply to have it paid out to you, that money can lay within the guardian's fund for the next 30 odd years until it prescribes.
Sure. Okay, that's very interesting. So we know now a little bit of the I guess the law behind intestate succession. Now, when we look at it, and you said, you're looking at either intestate or testate succession, and the way testate works is through a will. Tell us a little bit, I guess, about how wills are governed. What does the Wills Act allow you to do, I guess, if I'm passing away with a will? What's the law behind it? What are my options? What are my choices? And then I guess if you could maybe touch a little bit on the pros and cons between the two of them, or your perceived pros and cons between the two of them.
Okay, so when it comes to dying with a will, I think it's very important that people understand when you die or when you have a will in place, it helps to firstly distribute your assets. So it gives you the decision or control over the decision as to who should inherit from your estate. In terms of interstate succession, that may not necessarily be the case because it's working against blood ties and so on. As I mentioned previously, your life partner may not be able to inherit. In the case of a will, if you say, I leave my house, for example, to my life partner, then we know your life partner is protected. So it gives you freedom of choice as to who and how you'd like to dispose of your estate, and as to who can basically inherit from your estate. I think it's also important to know that in your will, you're allowed to basically appoint your own executor. So it also allows you to appoint a trusted individual or company who you know is going to administer the estate in accordance with your wishes and obviously the law. Another important fact is the fact that you are allowed to provide for a guardian in your will for your minor children. So you can appoint your spouse. You can appoint, should you and your spouse pass away or your life partner pass away, you can obviously appoint a family member that you trust to take care of your kids as well. And I think when you draft a will as well, it's very important that it reduces the amount of family disputes that occur when a person passes away. I mean, there's a lot of emotions, there's a lot of uncertainty that revolves around death, and having a will reduces all of those negative effects. As well as when you have a will, it allows for easier estate administration. So we as estate administrators, should we be approached by your family or be nominated to act as your executors, we will know, okay, person X decided that they wanted their assets to be distributed in this specific way. We know the exact direction to go into. So that's those are a few actually of the important points when it comes to having a will. Whereas the Interstate Succession Act just provides for an overall safety net. It doesn't literally say, okay, your house can go to your child so that they have a place to live when you pass away. So those are just a few things that are beneficial to having a will as compared to dying interstate succession without a will. So leaving it up basically to the law to decide how your estate should be administered. I mean, when you die interstate as well, there's no real clarity as to who is going to inherit in terms of maybe there may be misconceptions or any unintended heirs. Some heirs may feel like, it's unfair as to how the estate is being distributed. So you don't want to create that level of uncertainty when it comes to how your estate is distributed when you pass away.
No, 100%. Sure. That's very interesting. I think going back to it, and I think it's something people forget about, is how people don't realize this when you're alive. And I often say this to clients when dealing with them, when helping them with wills and stuff. And you say, listen, you might see someone and you might love them tremendously, and they love you.
Yes.
Their perception or what you perceive for them as a meaning or a connection between the two of you might be different for them. And it stops a lot of disputes, especially when people pass away. When in your will you say, I want you to have this, and this is the, I'm giving you this, and then it leaves it not for any disputes or any problems and things like that, because you're setting out what you want, your wishes, your thoughts, because you're not there to talk. And also, I think the nice thing about it, based on what you said, is it lets people know what assets you actually have, especially the executive of your estate. I know, and I'm sure you can speak more to this probably, well, most definitely, but finding people, if people pass away intestate, how do you know where to look? How do you know what assets they actually have? Becomes a bit of a rat race, and I'm sure that that adds to the time and the length on which it takes to wind up those estates, because you're spending a lot of time at the beginning just trying to find out where everything is and what everything is.
That's very true, Keegan, as well. When you die interstate, I think it adds, unintentionally, it adds a lot of delay to the administration of your estate, because firstly we need to get an executor appointed, and again it's moving along the lines of your closest blood relatives, being your spouse, your children, or your parents. And it's important that it's that bracket of your family that is now exempt from providing security at the master's office, whereas if it's your sibling, they may be liable to provide the master with a bond of security covering your assets. It also creates a lot of uncertainty when heirs are not able to be traced. So now executors have to go out and look for the possible beneficiaries, or the beneficiaries, maybe let's say, for example, kids, your brothers or your sisters or your parents that you may have not had contact with for a very long time. So that also can lead to a delay in the administration of your estate as well. And like you mentioned, sometimes if you don't have a life partner or a spouse, you just have kids, your kids may not know where all of your assets are. So that also leads the executor now to doing multiple searches as to, okay, what are the possible assets that this person may have had in their name at the time of death, as well as also all the liabilities that they may have had at the time of the death. So it can create a lot of unnecessary stress, a lot of tension and anxiety as well with your beneficiaries and your family, to try and gather as much information about your life after you've now passed on.
100%. And I think, just to go a little bit further on what you said there, especially at the end, is that it gives, I think the important thing, and as a lot of people don't take it, so firstly it's the practicality of winding up estates and finding that information about people, but it also gives people an opportunity to sit down with their loved ones and their closest ones and say, let's have a serious conversation, especially when you have children in the mix, you've got family, you've got expenses, you've got houses to pay off, cars to pay off. How are we going to do this? What happens if you pass away tomorrow? It gives you an opportunity to sit down, have the real conversation with the loved ones, because you'd be surprised, a lot of people are too afraid to have these conversations. You sit in consults, you'll know how many times has a person said, geez, this is actually, I've never really thought about this. This is actually a bit scary. This is this. And you're like, it is scary. It 100% is. But that's why you have to have these conversations. And that's why wills are important, because they force you to have that conversation to prepare, to protect your family and your loved ones in the unfortunate and unforeseen event that you aren't there, And I think just going on that, and then I want to go back, there was something I just wanted to say. You keep raising a valid will, as opposed to just saying will. What makes a will valid? What are the requirements? What do people need to look out for? That if they're just going to some random person who says, I can draw you up a will, what makes that will legal as opposed to not legal, to prevent, as you said earlier, disputes on that will? Because I think you can still dispute wills. What prevents those? What's the thing that people who maybe are getting guidance from banks, etc., not and they've got legal advisors or whatever, but they may not see the person who's drafting it, may not have that, they're dealing with their bankers or whatever, who aren't maybe professional attorneys or people with legal knowledge. What do they need to look out for?
So in order to have a legally valid will, your will must be written. You must be at the age of 16 or older. You must have the legal capacity to understand what is written in your will. You must be able, as the testator or the testatrix, you must sign every page of your will so that it indicates you've understood the contents of what's written here. You must have 2 independent witnesses. So I think this is something that's very overlooked when it comes to wills and when you sign your will, is that your independent witnesses cannot be people who are benefiting from your estate. So it cannot be your beneficiary. It cannot be your appointed executor either. So it has to be two completely independent individuals that are signing your will. And everybody needs to sign in the presence of everybody. So your witnesses must be there when you are signing your will, and you must be present when your witnesses are signing your will. That's also something that's very important. Your will must be dated. And the reason for that is because sometimes you will draft multiple wills throughout your lifetime. And when it comes to us lodging your will at the master once you've passed away, we need the most recent will. So the date helps us to identify which is the most recent will when it comes to your valid will as well. If you are unable to sign, you are able to use your thumbprint as a signature. However, there must be a commissioner of oaths that is present while you are placing your thumbprint on your will as well. So that commissioner of oaths will then provide a certificate to say that yes, this person has read and understood the contents of the will. They have signed using their thumbprint, and that certificate is often lodged with your will when we lodge it at the master's office after your death.
100% sure. Nee, thank you. You're teaching us an incredible amount. You really are very knowledgeable, and it's really insightful. And it's good to have these conversations just to give people, you know, these viewpoints and these facts about it that maybe sometimes they're not really privy to or don't know as lay people. It's really informative. Thank you very much. I think you're clearing up a lot for a lot of people, a lot of lay people who don't necessarily have the knowledge or the skills or to about this subject, but also where to find the information about the subject. You know, it's not that easy for a layperson to just go and pick up an act and understand it and read it straight away. So, yeah, no, really appreciate this. And I think a final question, maybe which would help the audience, you know, is what are the myths or the misconceptions surrounding wills and surrounding being able to own a will? You know, do I have to have investments and major assets to have a will, or, you know, could you break those out for us a little bit? Talk to me a bit more about that and just explain it for us if you don't mind.
All right, Keeks, that's actually a very good question, because I think a lot of people, when you ask, do you have a will? A lot of people will come back to you and tell you, but I don't have anything. I don't have any assets. And that's not necessarily true. I mean, a will is not only for a wealthy individual. A will is for every person that has assets. And an asset could be your bank account. It could be the money you have in the bank account. It could be your home. It can be your vehicle. Those
jewelry,
it could be yes, jewelry, exactly, paintings, anything of intrinsic value, any antiques, so to speak. So there is a lot of people who are under the impression that, hey, I don't need a will because I don't have much. So firstly, that's one misconception. Another is also how that ties into estate administration as well, is that sometimes, especially back in the day, where couples were married in community of property, and for example, the mom never worked. So she didn't really have much apart from a bank account where she would receive probably a stipend every month. People find it not important to report that death of the individual, or not consider that, hey, you know what, my mom needs a will because she has this. And often back then, couples were married in community of property, had property, they had homes. And it's a joint estate that ends up getting administered because your mom or the late wife is a 50% owner of that property. And that is now an asset that needs to be dealt with. And when there's no will, now we've got to consider, okay, how do the children benefit in terms of that will? How does the spouse benefit in terms of that will? I know a lot of people think, okay, because we were married, everything should come to me. But that's not necessarily the case.
And that's not how it works in intestate succession.
Exactly. So another misconception that people come out with when it comes to wills is that anybody can draft a will.
Yes.
And I think that's something that people need to get more aware about, because you can walk into a stationery store, for example, and you can see, oh, here's a will, and I'll just need to fill it in, answer the basic questions, and then, cool, I have a will. While that might be the case, it does not provide for everything that you need to account for in drafting your will. Number one, it may not account for who you appoint as your guardian, whether your executor must furnish security to the master's office or not. It doesn't account for any exclusions in your will or any inclusions of specific bequests, things that you may not necessarily think of when you're filling out that form. So it's very important that you do seek advice from a professional when drafting your will, because it also helps you do an estate plan.
100%.
So that could be like if you were an individual that had investments and that has multiple bank accounts or has assets that you inherited from your fathers or from your forefathers or anything like that, you need to account for it. You need to account for how does tax play a role in your estate when you pass away. Again, how are my children benefiting or accounted for in my will? And while we can say yes, okay, I leave 100,000 rand to my children, if we specifically don't mention in the will that, hey, this money now must be invested, for example, in a testamentary trust, this money can still go to the guardian's fund even though you have a will, because you haven't made a decision as to how that money should then be invested or
stored
used,
or protected. 100%.
to take care of your children, especially your minor children.
Yeah, these are really important facts, Amy. Really good information. Thank you very much for taking this time, just explaining it to everyone.
Definitely.
I think, people are, as we said earlier, or as I said earlier, often you come across people are afraid to have these conversations, to sit down and actually think about this. And until you face these fears and actually sit down with your loved one, sit down with a professional and understand what it is you need to look out for, what it is you need to be aware of, can you then start planning properly and making sure that when you're gone, you allow your surviving family members to actually just focus on the grieving process and let these details be dealt with in a proper and as less burdensome manner as possible, because it can be very burdensome. It can be, and that's what causes a lot of the fights, is because winding up in a state is not easy, and if you don't have the expertise or the people helping you or the knowledge, of who to approach, what to do, the emotional fighting that you're doing with yourself, the emotional hurt, gets very intertwined together, and that's how these massive feuds happen. That's how the fighting happens, and you don't want that for your family. That's the last thing you want, leaving your family. You want them to be happy, to be looked after, to be cared for, to have each other, to lean on each other.
Yeah, definitely, Keegan. I think one major factor that having a will plays is, again, like I mentioned previously, is providing certainty. People don't like, and you're right, people don't like having the conversation, hey, when I die, this is what needs to happen. Nobody really wants to think about death, and I get it. It's a sensitive topic, but it's even worse when a person passes away and your family has no direction. They don't know where to look. They don't know what to do next. Now, personally, I wouldn't want my family to go through such a situation where I'm now no longer in the picture. I can't tell you where things are. I'm not there to tell you where things are, and you don't want to, again, burden your family with the fact that, hey, I'm now grieving the loss of a loved one, but now I also have to sort out what happens to all of their stuff. What happens? Who do I approach? Where do I go? What happens? How long is the process? So it's important that when you are drafting a will, and even just having the conversation around what happens to me when I die, always seek expert advice. I mean, it's really important to understand, your family needs to understand, okay, when I'm no longer around, what happens next? What do I need? The documents that I need. So, and the will also, it's very important that you keep your will stored very safely, because you can draft the will, but if nobody knows where it is, it's not going to benefit your family in the way that you expect it to benefit. So storing it with your professional counterpart, for example, if you have appointed a bank or the family relative or even an attorney, for example, they need to be aware of where the original lays. And when you die, obviously this must go to the master's office. So again, it's having a will is so important because it makes you think about the things you don't usually think about. It allows you to address matters that people may think, okay, we'll cross that bridge when we get there. And we live in a time where it's so unpredictable. Life is unpredictable. And you want to make sure that everything you have, all your family is taken care of in the way that you do so while you're alive. You
100%.
want to make sure that they are taken care of when you pass away.
Thank you very much, Nee. That was really, really interesting. Appreciate your time, and I think everyone will benefit from hearing this and listening to this conversation, because I really do think it's valuable knowledge.